Well, hello, everyone, and thank you so much for joining today's webinar on the FTC's new teeth. We're taking your questions and providing you some answers on the new trade rules recently announced from the FTC on consumer reviews. And to help us navigate these waters, we have invited Jay Harris, legal counsel with Hudson Cook, to answer your questions, because I am definitely not a legal expert. And a lot of the questions we got from our client partners and industry friends during the registration require that expertise. And that is what Jay brings to the table. He has a career in residential property management and litigation, commercial agreements, and compliance. So I'm really excited to have him here with us. Again, Jay, thank you so much for joining us.
Thanks, Carl. I appreciate the opportunity. I would be remiss if I didn't give the usual disclaimer that while I am an attorney and Hudson Cook is a law firm, we're not your attorneys for those of you on the call with specific legal matters. So this is not legal advice specifically, but our observations about how this new trade rule would apply in certain situations that impact the industry.
Absolutely. Thank you for that. Now, during registration for this webinar, guests were allowed to ask several questions. And we compiled those questions. We ran an analysis on them, and we broke them down into several themes. So hopefully we'll be able to get to each of those questions during this webinar, but we do have a limited time. We've only got an hour together. So if there are any questions that don't get addressed, or if you have any questions as we're speaking, as we're presenting, go ahead and put those into the chat box. If we have time at the end of the webinar, we'll try to address them. If not, we will be sending out a follow-up email to all those who registered with a recap of today's conversation, along with any questions that were not quite addressed. So starting out, Samuel Levine, he's the director of the FTC's Bureau for Consumer Protection, and he's been pretty vocal on LinkedIn, posting content about this new trade rule and how, when it comes to our industry, multifamily housing, when we're providing housing, that they're taking their job very seriously to try to protect consumers, help them to make better decisions, and to create an honest and fair marketplace. Exactly is it that is going to go into effect on October this year? What did they just do that has got us all thinking about this again?
Yeah, that's a good way to set it up, Carla. So the Federal Trade Commission's new trade rule on consumer reviews and testimonials applies to advertisers generally, regardless of the product. And rental housing happens to fit under these, these broad requirements. And in some sense, the concepts aren't new here, right? So the FTC, which some housing providers I've talked to don't always think of as a regulator or an enforcement entity that they pay a lot of attention to. They pay attention to landlord-tenant laws, but the idea of a federal advertising law has been kind of a dormant topic. But these concepts are pretty well established in the advertising space. So for those of you that are familiar with the guides that we were talking about some a year ago, last summer, that the Federal Trade Commission updated, these were best practices advice for advertisers about how they would relate to reputation management, for example, how they would address media reviews that were encouraged or promoted by employees around the products that are advertised. What's new here as of October 21st is that there's an enforcement standard. So the FTC, in order to be able to bring enforcement matters on its own authority under the Federal Trade Commission Act for unfair and deceptive acts and practices, needs to have, according to the Supreme Court, some sort of enforceable rule. So the best practices of the guides, that's a good start. But in order to be able to bring enforcement claims and achieve settlements that can be up to $57,000 per violation, a trade rule is needed as kind of a minimum standard of performance. So that's why we have a rule, and it's effective October 21st. And on a go-forward basis, advertisers have certain activities that are prohibited, some of which have happened in the rental housing industry and have been subject to prior enforcement actions by the FTC. Those of you familiar with the Roomster case from a couple of years ago are familiar with the use of fake reviews or testimonials about properties, rental properties, and the availability of rental properties on certain listing sites. These bogus reviews were the subject of an enforcement matter about 2 years ago by the FTC. And so the proposed rule, as you talk about here, I know we've got several questions, probably 2 hours worth of questions to fit into 40 minutes or so, but it prohibits the use of fake reviews or testimonials, prohibits the reusing or repurposing of consumer reviews for a substantially different product. And paying for positive reviews or social media indicators is also prohibited. And we'll spend some time talking about the use of incentives for reviews, which is permitted with appropriate disclosure, versus the prohibited practice of paying for a 4 or 5 star review or saying specific positive things about a property or the services or something in exchange for compensation. So those are 3 prohibited practices. The other 3 are go to overly aggressive and prohibited reputation management activities. So suppressing honest negative reviews or paying for negative reviews about a competitor are prohibited. Permitting employees to write reviews without the proper disclosures are prohibited. And then finally, inflating the social media influence by buying likes, buying followers, whether they're real quote unquote followers who are paid or whether they are fake followers, by inflating social media influence and buying likes. This too is a prohibited practice. So there's a lot here to unpack, moving from a best practices model that we've had for several years now to one where these are minimum enforceable standards.
Well, that was a great introduction. So let's get right into the questions. So the first theme of questions that we received was all around detection and management of fake and biased reviews. But in this case, it's on the case of the consumer. So some of those questions were, how can businesses effectively detect and manage fake and spam reviews? What steps should be taken when an employee is found to have reviewed their own apartment or competitors under a pseudonym? What are the best practices for addressing reviews of ex-employees or evicted residents that may contain false information? And how should businesses respond to and possibly counteract fake reviews, including the use of, say, a review removal tool or a service? So It sounds to me like there's some concern around, as a business, as an operator, what responsibility do we have to make sure that the reviews that are being posted are real and accurate?
Right. Yeah, that's a good point. So there are a couple of concepts here to unpack, and these are the kinds of questions that I and my colleagues have been working with some clients who are anticipating the October 21st implementation date and making sure they have the right practices in place. So on detecting and managing fake or spam reviews, one expectation, one liability limitation approach is that businesses need to make sure they have a policy in place, a written policy for how they and their employees, as well as their marketing agents, use and are prohibited from using reviews and testimonials about the properties. So having a clear policy, communicating that to agencies that may be hired to do marketing activities, clearly communicating that to employees, not just in the marketing department, but those that are, let's say, trying to turn around a property on the property management side, and maybe trying to be overly entrepreneurial in talking about what a great property it's going to be in the future. Having for the corporate liability limitation, having a policy, training and communicating that clearly is part of detecting and managing fake or spam reviews. And this also goes to having some sort of reporting capability where an employee who detects this or is aware of this can report internally to management about possible violations of the policy. And so that's one part for sort of a corporate compliance perspective and training perspective. The other part is just the oversight over what's being said about your properties. And this fits with normal good business practices over understanding the reputation that the property has in the marketplace and looking to see if social media reviews about a property or about the brand of the company as a whole, the management company, for example, what people are saying about that in the market and reacting to that to the degree that there are misimpressions or undisclosed comments that are being made. So one thing that's important here, and this goes to the second question here about the pseudonym by the employee, is that the advertiser, let's say the management company, is expected to take steps where they know or they have reason to know that an employee is using a pseudonym to provide a review or maybe a negative review about a competitor. In this case, they're expected to take steps to communicate that that's not the policy of the company, that where an employee is reviewing a property that they're involved in the management of, for example, they need to disclose the relationship that they have to the property. And, for example, that this is an individual employed by the management company for property X, and so proactively to self-identify who they are and disclose that in the post. And similarly, that the post itself has to be accurate. If it's describing the consumer's experience, then this employee is accurately describing the experience they had, not just making it up. And so where there's reason to know or actual knowledge on the employer's part that somebody is not following this disclosure and authenticity or accuracy responsibility, then it's important that they take steps to communicate to the employee that's not appropriate under the employer's policy, and that they're expected to disclose who they are and talk about their actual experience in making a review or a post. And that includes not simply their own personal review, but also where they like or affirm a comment made by somebody else about the property. So next one goes to best practices about unhappy ex-employees or evicted residents that may contain false information. So here, the FTC rule is pretty clear that while there are certain behaviors that constitutes prohibited suppression of negative reviews on the one hand, on the other hand, a clear policy that's in place to treat alike reviews that contain false information, confidential information, obscene information, for example, that if that is part of a general practice and policy that the advertiser has and enforces consistently, that those kinds of reviews are okay to take down under that policy. And that's true whether it's the property management company or an agent on their behalf, a third party who's taking care of that. What's not okay, obviously, is to use the false or review process for these kinds of reputation management as a proxy that has the effect of removing from view all the derogatory reviews or substantially all the derogatory reviews. And that clearly is the practice that the FTC is going after with this particular rule.
Mm-hmm. Mm-hmm.
So what do you do? How do you respond and counteract fake reviews, including the use of review removal tools and services? I mean, first of all, understand, to the degree you're using an agent or you're instructing your employees to do it themselves, understand what the process is and how your agent goes about this. Make sure you're communicating, and there's language in the rule. We can help you with the details on this. But there are, as I just outlined, there are clear things that applied consistently with the policy, advertisers absolutely permitted, indeed expected to take down obscene reviews, those that disclose non-public information, and other types of information that are specified in the rule.
Absolutely. Every review website is going to have their own what we call content moderation policies, and most review websites have moderation policies that will automatically remove reviews if there are threats, if there's overly derogatory, if there's profanity. So there are already systems in place with most of the major review websites for this type of moderation. Now, there are subjective falsities, right? You have a lease. Someone thought that, they didn't have a late fee till the 10th. You charged it on the 5th. The residents maybe having a miscommunication. But I don't think those types of falsities would be grounds for having a review removed, right? That's where we need to make sure that we're clearly communicating our policy and procedures with residents, making sure they know how we manage a community, that they know our rules and procedures so that they're not caught off guard. And if they are caught off guard and they go online and they blow us up, our recommendation is to have that professional response that professionally and clearly communicates your consistent enforcement of the policies and procedures for your community. Our research also into consumer behavior, into prospects who are looking at reviews, says that when there is a negative review, and it's a one-off, maybe where a resident was really angry, so they go and they blow you up and they say things that might not be true, but their perception might have been slightly slanted, is, to have that response. Because when prospects are reading the reviews, they see that negative feedback as a one-off. And when they're reading negative reviews, what they're really looking for are themes. Is this consistent behavior that's happening over and over again? And when they see those themes, they're pretty confident that might be a problem at that community. But the one-off negative review, your response can actually turn that 1 star into a positive experience for a prospect. We know that review fraud is growing, and I think that's why the FTC is addressing this right now. It's an issue, and all systems, including Amazon, including Google, and including us here at Apartment Ratings, are dealing with an increase in review fraud on our sites. And we are all searching for that magic tool that's going to be able to identify every single fraudulent review and adjusting as technology becomes available. We also know that not every resident, not every prospect is looking for a 4 and 5 star apartment community. In fact, the vast majority of renters are looking for that sweet spot between 3.5 and 4 stars. 70% of renters are now filtering for and only reading your negative reviews. So sometimes your negative reviews become that opportunity through your response to shine online. So we don't need to be afraid, to a degree, of those one-offs every now and then. However, when you see those reviews that are personally identifying, threatening, vulgar, definitely flag those and bring those up into content moderation. I think the other thing to be aware of is trying to bury 1-star reviews. If you're using fake reviews, or if you're using paid systems or incentives to try to get rid of negative 1-star feedback, that can really come back around to have a negative effect on your overall reputation. There are a lot of forums out there. Renters aren't just reading reviews, they're talking to one another, they're finding each other online to try to get the real what is life like at this community, right? When they see those 4.5, 4.8 star ratings, they're not really trusting it, so they start to dig deeper.
That's right. I'll just say on that, the FTC has brought prior enforcement action in the fashion, cosmetics and fashion industry for basically using a third party for reputation management, and the FTC, in bringing the enforcement action and getting the settlement, had calculated the share of derogatory reviews or lower star reviews that never saw the light of day. And the rationale was that the client was supposed to review them and then approve them, but miraculously, the lower reviews never got approved and reviewed in any time.
Mm-hmm.
And so it's that kind of behavior that the advertiser is responsible for the activities of its agent. And the FTC, I believe, with this new enforcement capability, the fact that there's a minimum performance rule now, will be more active in the space going forward.
Absolutely. Absolutely. So when you guys are using reviews, let's say you have an internal website that solicits feedback and then you publish different reviews to your website. These rules are also governing that activity. So it's not just the third party review sites like Google, like Yelp, but it could also be your internal rating and review systems for your property management systems that get published to, say, an ILS or to your own community website. So we want to keep all of this in mind as we're doing that internal moderation. Okay, the next set of questions that we received are all about compliance with the FTC rules as far as marketing and review solicitation. And I even see some questions in the comments around review solicitation. So some of those questions that we received are, what are the implications of the FTC's new rules on using featured reviews and marketing strategies that highlight positive feedback? And under the new FTC guidelines, how can businesses legally conduct raffles or contests that encourage leaving reviews? And what considerations are there for legally asking for reviews, and how can these be incorporated into rewards programs without violating the new FTC rules?
Yep. All good questions, Paula. And we're still unpacking some of this. But here's what we can say. So in terms of featuring a review that highlights the positive feedback, so the FTC has been pretty clear that you can regularly say, of your residents, for example, if you liked us, post a review about us. That traditional tagline is fine and is is a specific exception to some of the broader prohibitions on practices. So they do understand the need to promote to customers the opportunity and the desire that the advertiser has to get some third-party support from reviews. And similarly, it appears that the rules permit the advertiser to highlight good reviews that have come up and say, here's what a few people have said about us. It's important that they not the advertiser not represent that these are all the reviews, but it's permissible under the new proposed rule to highlight some of the rules, as people do with kind of a review of the month and that kind of thing. Here's what people have to say about us from actual authentic reviews. Obviously, if you're going to shine the flashlight on a particular review, it's important to check and make sure this is what you think it is, that it is a resident who is representing an experience she or he had at the property. In terms of the raffle or incentive or contest, rewards programs fit in the same category, right? So these are incentives that are the driver for consumers to leave a review. The important part here is that the reviewer, the resident, is expected to disclose that this is an incented review, or that they're part of a contest in making the review about the property. Similarly, if if your program is get another 100 points in the rewards program this month, that too would be something to disclose that this is a review for an incentive. An incentive was offered for this review. And that disclosure, it's important, not simply that the resident understand this and do this, but also that the advertiser, the company, has explained, it has some guidance in conducting the contest, conducting the rewards program, communicated this specific expectation to the consumers that are participating in the program. So you want to have something to look back to when in the event there's a challenge and you see that several reviews about a new property have no disclosure in it, you want to be able to point to the steps that you've taken to communicate that the reviewer is expected to disclose that this is part of an incentive program that they're participating in.
And if they don't disclose that, they go online, they're really excited about their points or their raffle, they write the review, they forget to disclose.
Yep.
Do we have a responsibility then to disclose that in our response to the review?
Yeah. So in that case, if there is a responsibility to supplement the post or communicate with the resident and say, hey, I'm glad you were part of the incentive program, or remind them of their obligation to disclose that this was part of a contest or a incentive program that they were participating in.
Mm-hmm. Mm-hmm.
And I think just the other point on this is, obviously you're not dictating at all. Hey, we'll pay the incentive if there's a 5-star review, for each person with a 5-star review. That's a prohibited practice. Or, similarly, other benefits that specify what's said. Please say great things about the new pool enhancements that we have. Mm-hmm. That too is going to be prohibited. A prohibited kind of communication by the employer or the advertiser to a resident.
Okay, so this concept of clear and conspicuous disclosure, right, kind of comes into play.
Yep.
In regards to this. So if the resident doesn't, then it is our responsibility to either follow up with a response that does, or to go back to that resident and ask them to modify their review.
That's right. That's right. I think, if you have a sense of the scale of what we're talking about, is this an expectation that every single one every time has been found? I don't know that that's practical, but a firm that is looking to protect itself against enforcement activities or private plaintiffs' activities using this as a performance standard would be smart to have that policy in place, communicate it, and then follow up wherever they see a undisclosed review that is pretty clearly requiring a disclosure.
Yeah. And I'd like to put this into context, right? So we have an apartment community. Maybe it is, just your run-of-the-mill B apartment community, market rate. If we're sitting there online with 100 5-star reviews, there might be a disconnect. There might be what I like to call a misalignment between that expectation that our reviews are portraying, putting out there to the prospect, and the actual reality. And it seems to me, Jay, and tell me if I'm off base here, but when that disconnect, that misalignment between perception, reality increases, right? Maybe it's only this small, okay. But when it starts to get bigger, that's where risk comes into play, right? The more misalignment that we have with our reviews portraying one thing, reality being a very different thing, the more risk we have as an organization. Would that be about the way you would put it in a nutshell? Absolutely.
And we've talked a lot about reviews by residents appropriately in incentive programs. I think it's also important to recognize this for reviews by employees when it comes to the disclosures. Even the owner of the company, she needs to disclose that she's the owner of the company if that's not immediately clear from the name that this person has compared to the name of the company. And so, particularly on the employment side, we see that sometimes there are motivations to say, hey, we want to do everything we can to turn this property around. And particularly in those situations, it's important that the management company has something on record, in some cases, even to push back against the asset manager of the owner to say, we're going to follow the law when it comes to what we can say. And certainly a employee who's a resident can talk about her experience there. Certainly an employee who's not a resident can talk about the efforts that they're making to do new things at the property. But that relationship, resident or employee, needs to be disclosed in what's said
in the review.
That's right.
So full disclosure, I'm the current community manager. I've lived here for 2 years, and then the rest could go into their review and their assessment. we see here on the screen that there was a landlord in Madison that was using rent credits to solicit positive reviews, as Jay said. That is enforcement behavior. I like that when you say enforcement behavior. And the enforcement, again, when you say per violation, there was that, what was it? What was the dollar amount?
So this is $57,000 plus, a little over $57,000. It adjusts every year for inflation. Per activity, per event. So pretty quickly adds up to $1 million, where you have a repeat practice where there's no policy in place, no training, no disclosure to an agency that's doing the work, or to the employees, let's say, of the management company, about what's appropriate behavior.
Yeah. So if we're having incentives for our employees to get 5-star reviews and 4-star reviews, if we're doing commissions, if we're doing bonuses, if we're doing contests, right? That pressure that's put on the employee can lead to what I like to call biased review cultivation practices. And you can see here, these posts were screenshotted from leasing agent social online board, where they're asking one another to write reviews. And you can even see here that one where it says it's review time, and it's like the ugh face, like, oh, I can't believe we got to do this again, right? There's this tremendous pressure that we're putting on our team members to continually generate more and more online feedback. And that type of pressure, those types of practices, can lead to reviews that are violating these policies. So again, what Jay said over and over is have a policy in place, rethink your policies. Let's make sure that we're taking the pressure off, so that the reviews that we are cultivating are honest, authentic, and in alignment with reality. We really want those online reviews to align with the real experience that our renters are going to have after they sign the lease. Okay, a couple more questions around responsibility and liability. So who holds the responsibility for compliance with FTC rules, the individual managers, or the management company, or the asset owner? And how do the new FTC rules affect the anonymity of reviewers, particularly in terms of requiring disclosures of names? And what are the guidelines for reviews submitted by employees or their roommates, especially concerning disclosure of the relationship to the property?
Sure. So responsibility is with the advertiser here on the first question. And so if it is the management company that is putting together the ad campaign and developing that, maybe independent of whatever the asset owner has to say, the asset owner has hired them because of the management company's expertise in the market and communicating brand appeal and things like that. Then the advertisement, the entity that's coming up with the advertisement and communicating their social media policy to employees and to the agents, third-party agencies, marketing agencies they may use, is going to be the one responsible for the compliance. I will say also, though, that individual managers are specifically mentioned in the rule. Employees, managers, and officers of the company are all specifically identified as having responsibility to make sure that they're not encouraging reviews without disclosure. Right, that's a no-no to say to residents, or to say to a junior employee, go ahead, we're trying to turn this property around, give us a good review, but don't put any, we don't need to know who you are. Either don't self-identify, or change your identity. That's clearly going to be a responsibility problem for the manager, and potentially for the company. A company may be able to limit its exposure to the degree that it can show that this manager has gone off the reservation and did not follow the training, did not read the policy. And so, that's why we started where we did in this conversation, that having a policy and training on it is going to be important. So that's, it depends on the facts and circumstances, but that's who's going to be responsible in this case. In terms of the anonymity of reviewers and name disclosure, the expectation is pretty clear that if you're putting Daffy Duck on there, that's a fake review, regardless of whether it's an authentic experience that you had about living in the property. And so the expectation for, particularly for incentives, to encourage resident reviews or employee reviews that are made with disclosure, so that the reviewer is identifying who she is or who he is. For the guidelines on employees or roommates, so the employee disclosure obligation is we've talked about, and important to give that disclosure if you're a resident on the property and you disclose, yes, I've had a great time here. Fine, if that's accurate, but you also need to point out your role with just identify that you're an employee of the property or employee of the management company. In terms of a roommate, this needs to be their actual experience. They need to identify who they are, but there's no disclosure obligation if they, on their own say, without any incentive or encouragement, say this was a great property. I looked at the website. I had a great, year here. I'm going to say good things about it. If they're responding as sort of a general encouragement to make a review as a satisfied customer, that's fine. There's no additional disclosure that's needed in that case.
Okay, we had a question.
Really it's the incentive and the employee role that trigger most of the disclosure obligations. Go ahead.
So we had a question. It's around the liability. So is a management company liable for the policies of the third-party review reputation provider or supplier?
Yeah, so I potentially, yes. I think it's important to know what that policy or practice is. What's going on, and I think a question to ask and get some assurances about is whether the third-party provider is following these new requirements that take effect on the 21st of October. To the degree that the policy and practice, especially if you've had a couple of years experience with this third-party provider, that the policy and practice is they're doing a very good job of applying a neutral policy and taking down obscene and abusive and false and defamatory reviews, that seems to be okay. To the degree that it's a new provider and they're talking about boosting your reputation and you're not familiar with the methods and couldn't articulate it if you were asked about it, I would, if I were your counsel, and I'm not giving you legal advice, I'd want to understand better what the agency is doing and give them a copy of your policy that shows the expectation that they will follow the law and follow your policy. And as you talk with your own general counsel, it may be something to negotiate for in any service agreement.
Okay, and we're also getting a lot of questions about the reviewer disclosing their identity. So if a reviewer, let's say they're not going to use a pseudonym that's obviously fake, your example, Daffy Duck, right? That's not a real person.
Right.
But what if the reviewer leaves the review under anonymous and or verified resident?
Yeah, so these are tricky issues. I think it's important to look at the language of the rule. But what the FTC's view is that if this is a review from a resident who doesn't exist, or the experience did not happen, they didn't. They say I was a resident, but they never lived in the property, or that the experience they had wasn't accurate in some way, and it's difficult to understand, and all the times in which the management company would know or have any reason to know whether this was an accurate depiction of what the reviewer experienced. But the the expectation under the rule is that the consumer is disclosing who he is, and not and putting in more than just satisfied resident or angry resident or lukewarm resident, whatever it is, but that they're identifying who they are as part of the review.
Okay. We saw recently a settlement with the Onestar case. Can you go into a little bit of detail about what this case centered around?
Sure. Yeah. So this is what the FTC had to do a year ago when it didn't have this new rule. So in order to, this $36 million settlement is an accurate number. The defendants in this case didn't have the money, so it was reduced to the amount they were able to pay. They were also banned from coming back into the industry and using these acts and practices. But the actual legal basis for bringing the case was also under state law involving the New York Attorney General and 5 other attorneys general. So there's a lot of coordinated activity that the FTC engages in when it wants to go after an unfair, deceptive act or practice under this very broad general business fairness authority that it has for UDAP violations. So in this case, we have a listing service out of New York. It had hired AppWin, a third-party marketing agent, to create tens of thousands of iTunes and Gmail accounts, fake accounts that would flood the system with fake positive social media reviews. And there are other problems with this platform. There were several non-residential properties that were listed as available for rent on the property, just using the address. And so this was the basis for shutting down this entity and fining the defendants in this case. So some of the same concepts that we're talking about here, because there wasn't a minimum legal standard, there was, potentially an aggressive defendant who had more money might have been able to say, come get me. You don't have a minimum rule, and I may not be following your guides, but I'm not breaking any established rule for what an unfair and deceptive advertising practice is with social media reviews. That argument goes away as of a month from now. And so, this is an extreme example, I'll grant you, but it's also one in which the FTC has gone after the rental housing industry when there have been other extreme examples that they've been concerned about, such as lease language that prohibits subpar reviews, another activity that they've gone after.
Yep. We don't want any language in our lease prohibiting the speech of our residents, right?
Right. I think for a lot of people that'd be common sense, and yet, that's when the FTC looks at the rental housing industry, those are the outlier examples they see, and that's been some of their thinking and the basis for this new rulemaking too.
Okay, a couple more questions coming in around technical and operational adjustments. So how do platforms that gate reviews and offer incentives need to adjust in light of the new FTC regulations? And what are the rules concerning the display of reviews on social media and independent websites? And what should businesses know about pre-reviewing reviews and websites to ensure compliance? And how might the FTC rules impact how major third-party platforms like Yelp and Google handle reviews, especially those not directly associated with transactions?
Yep. So review gating and incentives, we've talked about this a little bit. I think the key thing when it comes to review management is that you've got a clear policy in place about the kinds of reviews that are impermissible, that you will take down, and you apply that, or your agent applies that uniformly across the board. And the language of the rule, we talked about examples of what those things are, obscene and reviews and abusive reviews and things like that. Those that disclose non-public information, for example. In terms of offering the incentives, the incentives are okay as long as they're incentives for review. not for the specific language of a review, and that such incentives are disclosed, that you have some instruction to the reviewer to disclose that she got participated in some incentive program in making the review. Displaying reviews on social media and independent websites. We talked about kind of managing for obscenity and other impermissible reviews with a policy. I think the other thing is that the FTC is also concerned about sort of reordering a bunch of reviews about your property where, let's say they're not in chronological order, but all the 5-star reviews are at top, and you've got to scroll down to the very bottom of the page of 50 reviews about a property to find the 1- and 2-star reviews. That kind of review sorting is a practice the FTC doesn't care for. Better to stay away from that. And in terms of managing on independent websites, again, your ability to monitor and respond to comments that are made about the property on Yelp or Google, your rights to explain, respond are still there. And even to request that Yelp or Google take down reviews that might violate your confidentiality or other policies that you have. Doesn't mean Yelp or Google will go along with that all the time, but you've got a right to continue to ask for displays and representations about your property on independent websites.
So again, thinking about this, if we think about it in terms of alignment, right? We're getting all this feedback, whether that feedback is internal or external. If there's that misalignment between the two, we're getting a lot of internal that's negative and we're pushing only the positive to external, that is going to create risk because you are receiving negative feedback, but only the positive feedback is being promoted online. So somewhere in there is suppression. If that suppression exists, there is risk, right?
Yep.
So your job as an operator is to mitigate and minimize that risk. Make your online presence, your reputation, align with the reality that your residents are experiencing. And sometimes in our industry, I hate to say it, but that does mean that we're going to have some upset folks. It's not like they're buying a television, right? It's not a pair of tennis shoes. This is a legal contract. But the good thing is that renters, prospects, they don't expect us to have perfect online ratings and reviews. In fact, they expect to see some negative feedback. So learning how to respond to that in a professional manner, respond to that with consistent enforcement of policies and procedures and with a customer service tone is really going to go a long way to setting your communities apart from their competition. And keeping that alignment is going to minimize the risk that you're going to have from these new rules and potential enforcement by your local representation. So also referring to the guides, right? And they talk about that. Distortion can be misleading, right? So this was part of the update that they did back in June of 2023. Sorting reviews by favorability, which Jay touched on, hiding or deleting or otherwise suppressing unfavorable reviews, labeling reviews is the most helpful, buying or otherwise incentivizing reviews that aren't being disclosed, and then threatening reviewers who publish negative reviews. That's also something we want to avoid. And the one thing we know right now, we did our Satisfax did the biannual online renter study, and we found that 22% of renters are reporting that the positive reviews that they have read online were misleading, that they did not align with their lived experience. And we're going to conduct that survey again at the end of 2025. Our hope is that we'll see that percentage go down. Unfortunately, what we are seeing on apartment ratings with the fraudulent activity that we're trying to combat is that percentage might be going up. And again, that's indicating that there's a sufficient amount of risk targeting our industry, right? Letting legislatures and elected officials use our industry as leverage to make a name for themselves, right? And to go after those violators. So just avoiding, incentivizing for only positive reviews. James has said that before. Not only can it land you on the nightly news or, in a social media post that goes viral, it's now also carrying a pretty big, hefty fine that could go along with each individual interaction. So here's the question that's on everybody's mind. I've seen it a couple of times in the comments. I promise I wasn't ignoring you. I knew I had it in the slides, but retroactivity and future implementation. Will the FTC's new regulations be applied retroactively? And what does that mean for existing reviews? And when do the new FTC rules officially take effect? And how should businesses prepare for this change?
Yeah, you bet. So October 21st is when they officially take effect. They were published. Final version was published in the Federal Register a couple months ago. And so there's been some time to prepare for the final rules. The rules are not retroactive. They apply on a go-forward basis. But I would be careful about the term retroactive in this sense, right? So to the degree that you had established practices, established relationships with agents that are working on your behalf, there's not a basis to say, well, we had this agreement in place with the advertising agent starting 6 months ago, so that should continue for the term of the agreement. That's not going to get you very far if there's some sort of complaint or enforcement matter. So it's important to communicate what your policy is to your agents, to your employees, and as we have been talking about, for fee managers, even to the investors, to understand if there were certain practices in the past that are now going to be prohibited, that your investors understand these expectations. It's a new mandatory level playing field as a result of these regs, but they're not expected to be applied retroactively to older posts. So that's a little take on that. How to prepare. We at Hudson Cook are helping firms to make sure they have a policy in place, make sure they're educating, as I mentioned, not just employees, but third-party agents, make sure that there's oversight and monitoring of what's said about your properties. You're presumably doing this already for business reasons, but it's also important to take the lens of a compliance perspective too, and make sure that that you have some oversight over what's said about your properties, how it's responded to, and even I would say if you've got a big property and you've got a new process of reputation management, new personnel who are doing that in a new region of your company, who might be new employees, that you are looking at what's being said about the property to see, as Carla said, to see if it's 150 5-star reviews that have appeared in the last 6 months for a decent but not phenomenal property. That may suggest that maybe you need to take a look at that region and see what all they're doing there, especially if that kind of practice is so pronounced and that those kinds of reviews as a group are such of an outlier. So that's a bit. Policy, training, oversight, and that will be helpful in the event that you have somebody who didn't get the message, is new to the company, didn't get the message with the training, didn't follow what you do at your property, but did it the old-fashioned way. And that's going to protect you as a manager or senior management of the company in the event there's a challenge to what's an isolated practice by one agency or one employee that you employ.
Yeah. A lot of questions coming in about testimonials on a website. And Jay, tell me if I'm interpreting this in error, But if I'm going to highlight a review or two on my website, maybe a few people said some really great things and I want to highlight that on my website, as long as I'm not misrepresenting their testimonial to be the overall feedback and impression. So I'm not saying we're, 4 out of 5 stars based off 100 people, and then here's just one review, right? I'm in alignment. I think I'm going to say that word over and over again. We need to align our public perception, our public reputations with the lived experiences of our residents. So if you're getting if you have a system that suppresses, and you're getting, let's say, every month 100 negative reviews, but only 10 positive reviews are being posted online, and you're 4.8 stars. Well, are you really, if you're getting 100 negative pieces of feedback that aren't being published online? So try to just balance out that internal feedback should be similar. It doesn't have to be exact. No one's balancing and making sure, counting pennies here, but it needs to be in alignment. Is the experience that your residents having with your internal feedback tools in balance with the experience that's being published to your external feedback tools, whether that be Google, Yelp, your own websites? Try to create that balance. And not only from a legal standpoint does that reduce that risk, but it also puts alignment into your prospects' perceptions, so that they're not maybe disappointed when they come to show up in tour, right? They have realistic expectations. Really goes a long way to increasing those closing ratios, right? We want to advertise what they are going to really experience when they come to tour that community and sign their lease.
That's right. I think if there's a big disconnect between some cultivated set of reviews that are on the property site that is really at variance with what's said about the same property on a Google site or some other place, multiple other places, that difference is detectable, and that's is an important piece of evidence or something to be aware of if you're monitoring for what kind of activity is going on at the property level. But so that's one point. But the other point, like we said before, you may draw attention to satisfied customers who have posted satisfied reviews.
Mm-hmm.
And that's certainly permissible to isolate them and draw some attention to that.
One last question. Given the level of fine per incident, how aggressive with the FTC be, or will the FTC be, given their role as a revenue generator for the government?
Yeah, it's a good question. I think I've heard that one before. A thoughtful question with a lot of experience behind it. So I think the FTC has hired more enforcement attorneys, as has the CFPB. And I think if we've got time, we're going to talk about one other recent activity just today that shows what they've been up to. But I would, given the growing attention to rental housing that the FTC and the CFPB have, I would look at social media marketing about rental housing with this new rule differently than I did 2 years ago. And absolutely, I think the point behind the question is a good one, that there's a motivation. The FTC attorneys get promoted and get recognized for their success in bringing enforcement matters. And if you look at the last 5-6 years of enforcement matters involving the rental housing industry, there's more activity coming along, and an attempt to expand rules so they apply to rental housing advertising. So I guess this is a 60-second pitch of a development today that, Carla, we just put in here. So thanks for adding this in. But I wanted to make sure that folks who spent time to be on the call and are still on are aware of this. And I know we're going to talk about this next month again on the 17th. So that's great. But today, I would encourage you, those involved in the marketing and advertising side, what we've just talked about for the last 58 minutes was sort of the application of a clear rule to practices under a rulemaking process. here today in this settlement about transparent pricing, fair and accurate advertising, and security deposit charge documentation. This is a settlement against a respected institutional rental housing provider with some key takeaways under no new rules, under new concepts in the settlement that are, I think, a bit of a warning for the advertising of prices, all-in pricing, not just rent, but all-in rent plus mandatory fee pricing is one of the expectations the FTC has based on today's settlement. And similarly, that the terms and the services in advertising, the FTC is reminding us that the truth in advertising, the UDAP advertising requirements apply to representations that are made about the resident's responsibility in renting a home at the property, and things, representations that are made in the advertising process about what they're responsible for in terms of maintenance and other obligations. We don't have time to go into this now, but I would point this out because this is advancing the law by enforcement rather than rulemaking, which we've been talking about mostly today. And I think it's worth a deeper dive when we've got a little more time next month.
Absolutely. Fee transparency, I think, is a topic that is becoming more and more prevalent in legislature. I think there was an entire, either a city or a state, I can't remember, Central North, that recently passed a law in regards to fee transparency. So we're going to have a Ready, Set, Respond in October 17th. We'll put some announcements out about that. We're going to talk a little bit more with Jay about fee transparency then. So we hope you'll be able to make it. Now, I saw a lot of questions in the comments we did not get to. Again, we're going to copy those. We're going to put out a document after the fact with some common questions and answers from this conversation with Jay. However, if you would like to reach out to Jay, here's his contact information. Hudson Cook has definitely been in the residential real estate arena for some time, and maybe a good resource for you for legal counsel. So definitely reach out to him also if you have any additional questions. Jay, thank you so much. We look forward to seeing you back again in October. And everyone who participated in the Q&A, submitted their questions, thank you. I think this was very beneficial, and hopefully you got a lot from it. So.
Very savvy audience. So thanks for having me, Carla, and thanks for letting me join you. Look forward to talking again next month.
Absolutely. Thank you, everyone. Take care.